I think prima facie means that the president, in consultation, so he's consulting for a reason. So he's consulting with the Council of State to determine whether a prima facie case exists and in relation to misbehavior and misconduct. And then if it's determined, for instance, by what that council recommend to him, that it's frivolous and vexatious, then he'll say that there's no prima facie case and then he won't refer the matter further. Prima facie basically means evidence. You see what I mean? For instance, when Akufo-Addo threw out Professor Asari's petition, I only just read it at 4 a.m. this morning, but it was actually a pretty decent document. Basically, does it meet the threshold of Article 146 in terms of evidence, not speculative, not rumor, and an appreciation of the administrative responsibilities of the Chief Justice? Because although the Chief Justice has a particular role, she has a very peculiar role, which gives her a lot of discretion. Do you see what I mean? And so is the petition before the council, does the petitioner have a clear understanding of the laws and rules governing the administration of justice and the peculiar roles and powers given to the CJ? And then I think the former Attorney General was quoting the case of Ajay Tum, that in that case it was said that it was distressing to note that nearly all the petitions were consistent of a second or third generation allegation against the CJ. So there wasn't anything coming from a victim per se of the CJ and things like that. So for me, that is what the council is actually going to be establishing. Because although on the one hand, public perception is, how come 95% of Akufo-Addo's cases, in terms of the Attorney General, went one way in terms of they won all their cases? What is before the council is a completely different matter in terms of they have to have a standard of misbehavior, incompetence, based on evidence, not speculative, not rumor, and actually come from a victim, perhaps, of the Chief Justice. So the standard is slightly different, in my opinion.
So have they been doing it wrongly, those that have allowed for the person who is to be investigated, who is accused, to bring a comment before a prima facie is made?
It's in camera, so it shouldn't have been done. But that's just a procedural infringement. It doesn't necessarily mean that it's a penalty, for unconstitutional disclosure, basically. So it should have been done differently, but there is a lot of public attention to this. And it's interesting to note that the rejection of Professor Asari's petition very well written. And I think it's that well written because the Chief Justice was allowed to give her comments. You see, so the way the current president has given her 10 days.
Do you know that for a fact?
Well, no, I think it was referred to her even before. It was referred to her even before it went to the council.
In the prima facie determination as communicated by the presidency, do you find it there that the Chief Justice was giving? Because it speaks about consulting with the Council of State and then rendering that opinion. Yes,
but one of your journalists called me around that time, and I distinctly remember that as soon as there was word of the petition, the Chief Justice was given time to respond.
Okay.
Whereas in this case, the council has sort of seen the document and now she's been given 10 days to respond. So it's the same difference, but I do think that if she speaks to the procedure of what she does, because she knows what she does, and the other advantage of this council, it has the benefit of a former Chief Justice.
That's correct.
It has the absolute benefit of that. And I think she's going to be the deciding factor for this.
A former Chief Justice who is now within some quarters being accused of denying Charlotte Osei to see her petition and to make, an input before the prima facie determination was made.
Yes, but again, it is about the peculiarity of the role which only she can speak to on that committee. For instance, Professor Asari said things like the practice direction. You know what I mean? She just kind of just issues all these practice directions and it's wrong. And yet, by law, practice directions are issued to bring consistency and certainty to procedures known to the courts that are yet to be set in writing in the court rules. So it basically means because she's seeing the reality of what's happening in the court, she issues a practice direction to be real.
Okay.
Another thing Asari brought up, for instance, he said basically that all cases can't go before the same judge. In terms of all cases for one person can't go before the same judge. But as you know in practice, if like there's a lot of cases to do with one person and they all relate to the same matter, we're talking about consolidation of cases before the same judge. You see, so the peculiarity of the role is something the former Chief Justice can speak to help that counsel determine whether the threshold of evidence, not speculative, not rumor, has been met.
And your point, okay.